Today's question comes from Michelle in Port St. Lucie, and she asks, what happens to my bank accounts when I die in Florida? Now, this is one of the most important questions you can ask because bank accounts are often the very first thing families need to access after someone passes away. So, let me break this down for you the Florida way. First, let me clear up a big misconception. Most people think that if they have a will, then they avoid probate. Their bank accounts automatically go to their family. But a will does not bypass probate. Your will only controls or informs some of the things that go through probate. And whether an account goes through probate depends entirely on how that account is set up. Florida is not going to guess at your intentions. It's going to look strictly at the way the account was titled. So let's look at these because there are three ways bank accounts pass when someone dies in Florida. Number one, the pay on death method or the transfer on death, POD or TOD. If you name a beneficiary on your account, the bank releases the money directly to that person. No probate, no delay, no court involvement. The beneficiary just brings a death certificate and identification to the bank, and they'll release the funds. The second way is a joint account with right of survivorship. If the account is joint and has survivorship, the surviving owner automatically becomes the full owner. They can walk into the bank, show the death certificate, and access everything immediately. Number three, individual accounts with no beneficiary. If the account is in your name alone and there is no POD or TOD beneficiary listed, that account must go through probate. There is no workaround. That's the law in Florida. Now, what does probate actually mean for bank accounts? As soon as the bank learns that the account owner has passed away, the bank is going to freeze that account. Now, your family cannot access the funds, not for funeral costs, not for mortgage payments, not for utilities, not for emergencies, not for anything. A petition must be filed with the court. A judge must appoint a personal representative. Only then can the bank legally release the money. For some families, that might take 2 or 3 or even 4 months, and for others, 6 months to a year. Meanwhile, the bills do not pause. So these are the three biggest problems that I see with bank accounts in Florida. Problem number one, outdated beneficiaries. Life changes, divorce, death, remarriage, fallouts, but people often forget to update their accounts. And here's the tough truth. The bank follows the paperwork, not your will. If your ex-spouse is still listed as the beneficiary, your ex-spouse gets the money. Problem number two, no beneficiary at all. This is the number one reason families end up in probate when they didn't need to. A missed beneficiary equals automatic court involvement. Problem number three, add in adult children as co-owners for convenience. This creates all kinds of unintended consequences. It exposes your money to your child's creditors or divorce. It creates Medicaid complications, and it may unintentionally disinherit other children because legally the surviving joint owner often gets everything. Convenience today should never create conflict tomorrow. So, what's your key takeaway? There isn't only one correct way to structure your account. So there's no one answer about what happens to my bank account, right? It depends. Some people use PODs or TODs. Some people use joint accounts appropriately. Some use trusts. The tool isn't the issue, the alignment is. You have to think about what you want to happen and set up your bank accounts accordingly. Your account setup must match your intentions. Your will, your beneficiaries, and your overall plan should all be working together, not against each other. So, what should you do today? Number one, check every bank account. Confirm who the beneficiary is. Don't assume. I want you to actually go and check. Number two, avoid adding adult children as co owners unless you fully understand the legal consequences. Number three, make sure your will, your account titles, and your estate plan all point in the same direction. Number 4, if you have a blended family or minor children, be especially careful. This is where mistakes cause the most damage and where good planning protects everyone. This is one of the easiest parts of your estate plan to fix while you're alive, and one of the most painful parts for families when it's done incorrectly. Michelle, I hope this helped to bring you some clarity, and I hope I answered your question. If you're in Florida and if you ever need guidance on how to set up your estate plan or anything regarding estate plan, I'm always here to help. If you have a question you'd like me to answer in a future episode, please drop it in the comment below. I'd love to break it down for you in plain English. I'm Attorney Otto. Plan wisely, live confidently, and I'll see you next time.